Okay, so we are going to pick up where we left off in the class, and that is continuing to talk about Article 2 of the Constitution and talking about the presidency, specifically how we elect the president. And we left off talking about criticisms of the Electoral College, which there are many, and there continue to be a lot of criticisms. But there are, on the flip side, arguments of people from people who believe that there are reasons to keep the Electoral College, and so I've listed 5 reasons to keep the Electoral College. There are people who do believe genuinely that a reason to keep the Electoral College is because it contributes to the narrative that it is specifically unique to the American political system, that it is something that is entirely American, and therefore there's no need to change the Constitution. It is something that is tied directly to American history, and therefore we shouldn't. We shouldn't have to change it. There is something nostalgic to it. And while that is a bit problematic, that is an actual argument that people tend to use. Then there's the argument that the Electoral College was established to protect the interest of the states. And that is especially used when we talk about smaller states or states with smaller size populations. Like, for example, the argument of states such as Wyoming or Rhode Island. With states with smaller population sizes where there are larger rural populations rather than urban populations. Now, this can be used for both sides of the argument. Keep that in mind. So, for example, when we talk about situations where the popular vote is not reflected by the Electoral College, there have been plenty of people who have said that this is completely unfair when most people live in urban areas, when people are essentially being outvoted by these smaller size states, then these presidential elections are not truly reflective of them. The flip side of that is to say that the Electoral College gives every state at least 3 votes, and many elections have been turned because of such things. So, for example, it values, you know, every state's votes equally. So Wyoming's votes are just as valuable as California's. They're just as valuable as Oklahoma's, as Rhode Island's, as Virginia's. Um, and that was something that the founders had intended, that every state would be valued regardless of their population size. The next argument was that the Electoral College would cut down on voter fraud and corruption. Very few states have managed to establish a comprehensive and truly intelligent way to vote, and that's really problematic considering that we are now in the 21st century. But the reality is that it depends on which state you're talking about. Now, Oklahoma has a pretty good system established. It took a little while, but we are a state that has a pretty comprehensive and universal system that actually works. It's universal throughout all 77 counties. Florida, it took a gigantic mess up in 2000, but after the 2000 election, Florida fixed it, and the way that they've fixed it actually works for them. There are other states that have a lot of work to do, and because of that, because of substandard technology, because of this refusal to catch up with the 21st century, there are some issues, and so that's a part of the reason why the Electoral College is still in place. Then, of course, there's the argument against third parties, right? So in the criticism of the third of the Electoral College, we talked about people who want third party candidates, and in a two-party system, you can't have third party candidates. Well, here's the other side to that, and that is, third party candidates aren't necessarily the most ideal. And one of the reasons why is because when we talk about countries where you have population sizes as large as ours, which we have a very large population size, um, you are talking about a much more difficult process, right? Here's the thing that you have to understand. So in the United States, and this is something that, first of all, when we talk about places where you have in plurality systems of plurality, like in countries like in Europe, uh, they are able to choose candidates from multiple parties, right? And so they've figured out how they can have candidates from different parties serve in their different chambers of government. But for the United States, we have a population size of over 330 million people. And to have such a huge population from 50 states, all with states of having different types of election processes. And then on top of that, to add a plurality system to it, that's going to make things much more complicated, right? And then to be able to try and indicate that you are going to have a threshold of 30%. And so a candidate who wins 30% of your state's vote would automatically be able to win a certain number of seats, or your party would be able to get a certain amount of representation in Congress. That becomes much more difficult to determine. So it gets much more complicated. And think about this for a second. We can barely handle the two parties as it is. So that's what a lot of these people are arguing, right? So that's the that's the other side of the argument. Now, the last argument is this: changing the Constitution does take an amendment, and getting congressional members from those smaller states like Wyoming, like Rhode Island, going into the states of the Great Plains area where they value having that influential say in the Electoral College, and convincing those people that getting rid of the Electoral College would be worthwhile, is really going to be difficult, if not impossible, right? Even if a bill proposing the Electoral College made its way through the Congress, eliminating the Electoral College would take the approval of 38 states. Remember that, right? So even if both the House of Representatives and the Senate approved that bill, it would still have to be ratified by 38 states, which, again, that's not going to happen, right? Americans don't really, for the most part, don't really have a whole lot of enthusiasm behind this particular issue. It's not something that you're going to get a whole lot of support behind. So it's probably going to be here for the long haul, and you kind of have to figure out how to work your way around it. And that's kind of how it goes. Okay, so the next issue that we get into, of course, is the responsibilities of the president. What happens? What are you expected to do once you are elected and inaugurated as president? Now, this is addressed in much more detail in SkyPack, so I expect you to read and understand this much better. But these are the primary responsibilities, right? As president of the United States, this is what's listed in the Constitution. This is what's listed in Article 2. As President of the United States, you serve as the head of state. This is a largely ceremonial position. So this means, responsibilities such as if you are a war hero and the president is awarding you a congressional Presidential Medal of Honor or Presidential Medal of Freedom. When the president goes to make visits to other nations, or the president is welcoming a dignitary to the White House. This is what the Constitution means by head of state. This is something that is very ceremonial. But one of the things that a lot of critics will say is that this is sort of a distraction. It's not a very serious part of the position. However, I would argue that it's actually incredibly serious, because one of the things that people don't realize, particularly during the ceremonial visits to other countries, or when heads of state visit the president at the White House for state dinners and that sort of thing, is that behind the scenes, there are conversations taking place. There are conversations taking place among the diplomats. There are conversations taking place even between the president and foreign dignitaries. And these conversations are incredibly important. So even though these are ceremonies, there are conversations, diplomatic conversations that matter. And that's why this is important. Now, the next role is chief executive. And as chief executive, the president is required to enforce the law. This is his primary responsibility as president of the United States, to enforce the laws of Congress and to enforce the decisions of the Supreme Court. This is usually done through executive orders, right? So, in an executive order is essentially, and you can see this often when a president has a photo op of some kind, especially in the White House, in either the Oval Office or one of the rooms of the White House in the West Wing. You'll see photos of this, but the presidents usually will, through an executive order, be seen pictured signing an executive order. This is what the president is doing, enforcing whatever the Congress or Supreme Court has done. Presidents have issued over 13,000 executive orders. And here's the thing that you need to understand about executive orders. Executive orders are issued only to federal agencies. The president cannot issue an executive order to a state government. So the president cannot send an executive order to the governor of Oklahoma. The state government cannot receive an executive order at all. That is not how it works. It is only directed to federal agencies. So, the Veterans Affairs Departments, Department of Education, anything that is affiliated as a federal agency, those things that are affiliated with the federal government, they are directly impacted by executive orders, but that is it. The president, as a chief executive, can also enjoy appointment powers. So, as a chief executive, he appoints people to different positions, to different jobs. So, members of the cabinet, so Secretary of Education, Secretary of Treasury, Secretary of Transportation, Secretary of State, those positions are appointed positions by the President of the United States. Now, just because he's appointed them doesn't mean they get the job. They have to go through a confirmation process, but he still gets to appoint them to those positions. They have to go through the confirmation process through the Senate. The Senate has the responsibility of confirming and then approving them officially, but the president has that job. And also, as chief executive, the president has emergency powers. So, as if there is a sort of an extreme situation, whether it's an attack, if there is an attack of war, if there is a natural disaster, as chief executive, he can take emergency powers and do whatever that needs to be done. And then, of course, there is the presidential pardon. That's done as a chief executive. The most famous presidential pardon, of course, is the pardon issued by Gerald Ford to Richard Nixon. Okay, now the chief legislator position is a little bit tricky because this is where people get confused. And so the other day, I told you guys, or a couple classes ago, I told you guys that this is where people sort of misinterpret the president's role. A lot of people believe that the president gets to pass legislation, and I want to make sure that you understand this clearly. The president does not pass any legislation. The president, as a chief legislator, proposes legislation. The chief legislator and not only gets to, but he is expected to. You don't, you are expected to reach out to different legislators, different congressmen, different senators, and connect with them, talk to them about your ideas, talk to them about your campaign proposals, and say, this is what I believe is the responsibility that we have at this point in time, and I believe your name can be connected into it. Also, as chief legislator, the president can call Congress into an emergency session. Franklin Roosevelt will do this. When he becomes president of the United States, and he says, we are in, I mean, the Great Depression is essentially like, is not just a regular economic emergency. This is almost a time of war. We can't wait a couple of weeks. We need to get into session right now. And so he calls an emergency session. Um, the the other function that the chief legislator has is the veto, and it's probably the most important power that the chief legislator has. The veto is the ability to take a bill that Congress proposes and say, absolutely not. This is not going to work. The first six presidents of the United States, that's George Washington all the way up through John Quincy Adams, the first six presidents used the veto very sparingly. They did not use it that much at all. In fact, from George Washington to John Quincy Adams, they used the veto in total about 10 times, primarily because if they believed that a bill was unconstitutional, they vetoed it. So they didn't veto a bill because they disagreed with it. They vetoed a bill because they believed it was unconstitutional. It's important that you know that, right? They did not veto a bill because they disagreed with it. They vetoed a bill because they believed it was unconstitutional. That changes with Andrew Jackson. Andrew Jackson, who is the seventh president, would start to change the reason why presidents used the veto. He would start using the veto on the grounds of politics, on the grounds of policy. He himself, as president of the United States, by himself would use the veto a total of 12 times. 12 times. And the reason why is because he just did not agree with the bill. He would veto what Congress passed because he did not like the bill. And what ends up happening is the veto would greatly enhance presidential power. Andrew Jackson, using the veto 12 times during his presidency, gave future presidents the permission to use veto power as a way of increasing their political power, right? So it wasn't just about constitutionality, it was about political power. Um, that's that's really significant. Um, there used to be this thing called the line item veto, where a president could veto specific things, specific parts of a bill that he didn't like. Um, the reason being was because in the 1980s and the 1990s, Congress would add things onto a bill like pet projects and things like that. And Ronald Reagan in the 1980s pushed really hard for a uh, thing like a line item veto, which allowed him to um, essentially veto specific things in a bill. And in 1998, the Supreme Court basically said that line item vetoes was essentially unconstitutional. He couldn't do that anymore. I mentioned earlier that the president was also uh, a chief diplomat. So the president is responsible for the conduct of foreign policy, which foreign policy, of course, is our relationship and our policies with um, the rest of the world. And this is the thing: the president is supported in that kind of um, relationship by the State Department, right? And the right now the Secretary of State is a man named Antony Blinken, and so essentially, what happens is the Secretary of State, who's the guy who will go out and negotiate treaties, and he'll go out and meet with foreign dignitaries. He goes out and he represents the country, primarily the president's agenda, and he'll go out and negotiate and do all of that stuff. But primarily, it is the president's agenda, and it's what the president assigns for him to do. Um, but at the same time, the president will be the one who is the chief um, architect, right? He's the guy who is creating and conducting this foreign policy. He's the guy who's going to say yes to this foreign policy, yes to this treaty, yes to these executive agreements. The Constitution gives the president the sole authority to negotiate treaties and international agreements. However, this is important. The Senate has to approve these treaties, right? So the president doesn't have the sole authority here. The Senate has to approve them. So the president isn't the only guy in charge here. And it's important that the president has established a relationship with the Senate where the Senate is in good understanding of what the president is trying to accomplish and what is going on out in the world and with these particular foreign nations and with these foreign leaders, right? They have to have a clear communication with each other. Um, so, you know, uh, when we talk about foreign policy and all of these things, it's important that the president is clear in his communication with the Senate, but also with his Secretary of State. That has to be important because if it's not, then you get multiple messages and it can lead to chaos. The other thing is that when we talk about this kind of representation, it's also important for where the United States stands globally, right? Because the president is the face of the country. And especially in this day and age, how the country is represented is incredibly important because of what that is going to reflect in treaties and in negotiations um, with multiple countries, right? If a president enters into something called an executive agreement, the president can do that without Senate approval, but the agreement only lasts as long as the presidency. So that's something to bear in mind. The executive agreement is only as long as the presidency is. So if the presidency lasts for 8 years, then that's how long the agreement lasts. A treaty is as long as the terms of the treaty lasts. So there's that. Now, the most power a president will exercise, of course, is as the commander in chief. The commander in chief is his role as the one in charge of the military, the one with final say over the military. And here's the thing. This role was fashioned with George Washington in mind. It put the military under the firm control of a civilian. And that's important for you to understand. It is important. It is an important distinction for you to make in your notes. Military uh, with the power of a civilian, right? The civilian has full control over the military, even if the guy in charge, whether it is George Washington, whether it is Ulysses S. Grant or Dwight D. Eisenhower, these three men were former generals, right? Dwight D. Eisenhower had been the supreme commander of the Allied forces during World War II. So you want to talk about an incredibly powerful man with military authority. That's Dwight D. Eisenhower, right? But when they served as president, there was a full and complete constitutional understanding that they were not men of the military. They were men, right? They were presidents of the United States, and that was all. So when they went into the office, every morning they would wear, suits and ties. Now George Washington did not, because that was not the fashion at the time, but Ulysses S. Grant and Dwight Eisenhower did. They wore suits and ties, and that was incredibly important for them to understand, and it was important for everyone else to understand that they were the president and not generals. And it was important for us to understand that as well as Americans, because we were not a country that were going to allow the military to run a republic. It was a country that would be run and decided by and led by civilians, not the military. These are important distinctions for you to understand. The Constitution is establishing in Article 2 that the President of the United States, even with a military background, was a civilian. And a civilian would be elected into office, and a civilian would be in charge of the military, not a general, nothing like that. The idea was that regardless of what their history was, what their personal history was, what their career background was, it did not matter. It was that this was a republic with the values of that valued democracy and not military values. And that was incredibly important, right? The president is not expected to lead troops into battle. Instead, the president is expected to make key military decisions. The president is expected to have uh, the final say on key military decisions, even without having military experience or a military background. This is the thing. The president will be surrounded by military advisors, and these military advisors are entrusted with the responsibility of giving the president the best and most solid military advice, what is in the best interest of the United States, and what is in the best interest of their allies, of the American allies. And then the president makes the decision. And the military has to go with what is in the best interest of the country and what is in the best interest of the president. That's the whole point, right? That's the idea. Now, being commander in chief, the idea is also this. The president cannot declare war. And we talked about that the other day. Only Congress can declare war. Now, that said, there have been instances where the president has ordered troops to take military action without formally declaring war. And that has happened in Vietnam, in Korea, in the first Gulf War, which took place in 1991, in Iraq, and in the most recent war in Iraq and in Afghanistan. None of these were formally declared wars. Instead, what these presidents have done, and those would be Presidents Truman, Lyndon Johnson, George H.W. Bush, and George W. Bush. What these presidents did was essentially declare them um, uh, basically things like police actions, taking on acts of terrorism, different things like that, depending on the scenario, right? We were fighting an ideology, we were taking on a movement, we were not declaring war on a particular country, we were declaring war on an ideology, whether it was communism or terrorism. And therefore, because we were not formally declaring war on a country, um, those presidents avoided Congress altogether. Now, the Constitution makes it clear that declaring war is an act of Congress, but quite frankly, many members of Congress actually prefer this idea of putting the burden on the president, because that way, if things go wrong, they can go to the media and basically put all the blame on the president. You know what I mean? This is the thing. You can blame the president when everything goes to hell in a handbasket, or you can throw a lot of patriotism this way and that way and wave the flag and say that, everything's going great and God bless America. Now, that said, that brings us to the issue of accountability and the impeachment process. And I want to talk about why the impeachment process is important. And Ben Franklin is the guy who actually introduces the idea of impeachment. So this quote actually uh, comes from Franklin. Franklin says that without a system of accountability, then you're guaranteed to have an assassination. And what he means by that is, um, if our authority figures, if the person in the highest position of power or in this executive position, this executive office, isn't held accountable, then the people will find a way to hold them accountable, right? Because here's the thing, we are entrusting this person with a tremendous amount of power. And if this person is not a trustworthy person, if this person is not a good person, if this person breaks the law and that Congress is not holding them accountable and does not have the means to hold them accountable, then we're in trouble, because the people, the American people, will find a way to hold them accountable. And accountability is everything, because, many, 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 many years later, Theodore Roosevelt will say something similar. Theodore Roosevelt will say that no man is above the law. And he believes that very passionately. No man is above the law. And that includes the President of the United States. No one is above the law. The 14th Amendment emphasizes that, right? The 14th Amendment, as we will see in a second, is talking about this, right? So let's talk about how impeachment is presented in the Constitution. So Article 2 of the Constitution is really interesting because the setup is already presented in Article 1. So the process of impeachment is presented uh, in in Congress, right? So it is the House is it's the House's responsibility to come up with the charges against everyone, any official, right? Whether we're talking about the president of the United States, the vice president of the United States, um, any government official can be impeached, right? So the president and the vice president uh, have to be tried in this whole process, right? And the House of Representatives is responsible for coming up with the charges against the president or against the vice president. It depends on who's committed the crime or who they claim or allege has committed the crime. And then the trial of the president or the vice president is played out in the Senate. Now, when it is played out in the Senate, it is members of the House of Representatives who will actually be the prosecution, right? So members of the House of Representatives are the ones who actually present the case against the president or the vice president. And members of the Senate are essentially the jury. They are the ones who will vote and decide whether or not the president or the vice president will be impeached. Now, the person who oversees the trial in the Senate is actually the Chief Justice of the Supreme Court. So, for example, when Donald Trump was impeached for both of his impeachment trials, it was the same process where John Roberts, who serves as the Chief Justice of the Supreme Court, had to serve as the judge over the trial in the Senate, where while representatives from the House served as the prosecution and presented their case, and the Senate, you know, they did not have enough votes in the Senate to impeach and remove. The House voted both times to impeach Donald Trump, right? The House voted both times. They successfully voted to impeach Donald Trump, but the Senate did not successfully remove Donald Trump from office. And that's the decision. So the House can vote to impeach, but the Senate will have to decide to remove. Now, what can the president and any other government official charge be charged with? They can be charged on the following grounds: treason, bribery, and high crimes and misdemeanors. High crimes and misdemeanors tend to be the typical charges filed against officials. High crimes and misdemeanors tend to be the larger category that these crimes tend to fit under. But treason's a big one, right? And here's the thing: when we talk about why this is such a big deal, I want to come back and remind you about what we talked about in Module 4, and that is the 14th Amendment. And remember, in the 14th Amendment, it lists for us the responsibilities that the country has to us as citizens, right? It tells us all of the things that we are granted as citizens of the United States, right? The things that we are guaranteed. However, on the other side of it, there are responsibilities that we have as citizens of the United States. We are held accountable for all of the things that we do not do or the things that we fall short of. And this is what happens as a government official if we fall short of those things. And one of those things is, if as a government official, if we fall short, then we are held accountable, right? And this is what it means. If you have committed treason against the United States, then you cannot run for office, and that's in one of the aspects of the 14th Amendment, right? And that's how this sort of comes together. One of the key things that people tend to forget is that there is a level of responsibility here when we talk about w- uh, what it means and why it matters when people um, are brought up on charges of impeachment. Impeachment is not a silly, simple, casual thing. Impeachment is incredibly egregious. It is a terrible thing. It is a terrible mark because impeachment means that you have been accused of bringing some sort of harm to the office that you have taken in some cases, right? So, again, the House of Representatives actually impeaches, but the Senate has to decide whether or not you are to be removed. Now, here's the key: the House can decide to impeach by a simple majority vote. So if there is a simple majority in the House, you can be impeached. The Senate, it is more complicated, right? The Senate has to have a two-thirds majority in order to remove you from office. And that is very difficult. And when we talk about the difficulty of this process, um, the reason why it's so difficult is because you have to prove beyond a shadow of a doubt that the offenses committed were worthy of removal from office, right? So when the prosecution from the House of Representatives goes to the Senate and makes their case before these senators, they have to be able to demonstrate that these charges against this particular official, be it the president or the vice president, is beyond a shadow of a doubt. And this is the key. So I want to get into a couple of technicalities here. When we talk about impeachment itself, just the act of impeachment, impeachment only means that there is enough evidence to stand trial, right? Impeachment means that there is enough evidence to stand trial. So if the House has impeached you, that means that the House says you can now go to the Senate and stand trial if you have actually been impeached. Being brought up on charges of impeachment doesn't mean anything. But actually being impeached means that it's going to go to the Senate. Now, to be impeached and removed means that it's over, right? You are now removed from office. Um, that has not yet happened in American history, but uh, in our history, um, three presidents have been impeached. None of them have been found guilty. So, Andrew Johnson, who was the president right after Abraham Lincoln, was impeached. And Andrew Johnson, Bill Clinton, and Donald Trump. Now, all of these presidents were impeached under highly partisan circumstances. And so, when you study these things historically, you have to wonder, okay, how seriously can we take these situations? Has it been tainted? Like, how critically can we look at this? Um, but here's a couple of things to keep in mind. Andrew Johnson was literally one vote shy of being removed from office in the Senate. He was one vote shy of being removed from office. So there's that. Bill Clinton was impeached in the House, did not come close to being removed, and then left the White House after serving 8 years as president, and actually left with some of the highest ratings as president of the United States um, in American history. He left incredibly popular. Um, Donald Trump is the only president to be impeached twice and the only president to be impeached twice in one term. But then in that same sentence, he's the only president to be impeached twice in one term, but never removed. Now, where does Richard Nixon fit in here? Richard Nixon was going to be brought up on charges of impeachment. He resigned before it went to the vote. The reason why he left was because it was clear that not only was he going to be impeached, it was clear in the Senate that he would have been removed. There were Republicans in the Senate who were going to vote for his removal. I mean, they didn't even need a trial. They knew that this man was a problem. So that's the thing. Richard Nixon saw what was coming, and so he resigned before impeachment actually took place. So Nixon beat impeachment charges. And then, of course, he was pardoned. So pardoned before anything could happen to him, and he was never held accountable to anything that took place. Okay. So there are amendments in the Constitution. This is going to bring us back to amendments in general. But there are amendments in the Constitution that are specifically about the presidency. And I want to address what those amendments are and why they matter. There are some of them are politically driven, and some of them are designed to protect the American people and protect the stability of the presidency in general. So when we talk about these amendments, there are four in particular. The first one being the 12th Amendment. The 12th Amendment was ratified in 1804. And when we talk about this in particular, it provided separate ballots for vice presidential and presidential candidates. And this was proposed and ratified as a result of the election of 1800. So in 1800, here's what's going on. And I don't think I have it up here, but um, so there were four candidates in 1800. John Adams, Charles Pinckney, Thomas Jefferson, and Aaron Burr. And so the Constitution at the time decreed that whoever got the most electoral votes was president, and whoever was the runner up was vice president. So first place, president; second place, vice president. And there was on the ballot itself that existed at the time, there was no need to distinguish between the presidential candidate and the vice presidential candidate. But here was the problem. By 1800, there was a quick rise in political parties, right? There was the Federalist Party, and then there was the Democrat Republicans. Democrat Republicans, by the way, and I don't know, again, let me just double check on this. So the Democrat Republicans is the name of the other party, Democrat-Republicans. Democrat Republicans was the other party. So the Federalists saw John Adams, as their presidential candidate. And they liked Adams, and they saw Charles Pinckney as the natural candidate for vice president. And the Democrat Republicans saw Jefferson as their presidential candidate, and Aaron Burr would be their vice presidential candidate. That's that was the natural way that they would go. And again, Aaron Burr is not necessarily their favorite choice. Aaron Burr was not was a guy who sort of made politically convenient decisions for himself. Whatever what would win him the office is really what he did. But at that point, they saw him on the ballot, and they thought, okay, if he's going to identify himself as a Democrat Republican, then we'll put him on as VP. But the Constitution, of course, isn't making any such recognition. The Constitution's not seeing anybody as VP or president, not calling for the ballot to create any such, notifications or distinctions, anything like that. So when the people voted, what ended up happening was the Federalists had no chance whatsoever. Adams and Pinckney were eliminated with 65 electoral votes because there was no such thing as the popular vote yet. And Jefferson and Burr were tied at 71. So if it had been clear that Jefferson was the presidential candidate, the problem would have been over automatically because Jefferson would have been the president and Burr would have been the vice president. But again, as you guys will remember, the Constitution does set it up to where it says, well, if you don't have enough electoral votes, the decision goes to the House of Representatives. So that's what happens. The decision goes to the House of Representatives, and the House votes. The House votes, and they cannot decide. The House votes 35 different times. There are 35 ballots, and the presidency finally goes to Jefferson with Burr as the vice president. The reason why it goes to Jefferson was because um, people started to send appeals to significant leaders. One of those people, and if you guys are familiar with Alexander Hamilton or the Hamilton Broadway play, you'll know this story. Alexander Hamilton actually steps in and encourages Federalists in the House to vote for Jefferson instead of Burr. They had been going back and forth. Federalists were hemming and hawing. Some were voting for Burr because Burr at one point had been a Federalist, but then, again, he was a man of political convenience. And some had been voting for Jefferson. And then Hamilton steps in and he writes this essay and says, listen, guys, I'm not a huge Jefferson fan. He and I disagree on all of the things, but at least Jefferson has a point of view. At least we all know where Jefferson is coming from. Jefferson's got ideas. He's got a perspective. Burr bends with the wind and doesn't have he's a man of political convenience. He has no decision making skills whatsoever. And I would go with Jefferson. I recommend that you throw your support behind Jefferson. And that's what they do. They vote for Jefferson as the lesser of two evils because at least you know or you can predict what Jefferson is going to do. So that's again that's what ends up happening. What it leads to, and again, if you are familiar with the Hamilton Broadway play, uh, there's a moment where Jefferson will say, mumble under his breath, yeah, we have to get this taken care of. They do. The 12th Amendment is specifically about we are going to choose who is the president and who is the vice president because we cannot have this mess happen ever again. They fix this idea that you are going to have absolute chaos in the light of elections. Never, never again. The 20th Amendment of 1933 addresses the issue of the lame duck. The lame duck amendment is basically addressing the inauguration date. So initially, presidential inaugurations were set for March of March of the following year after a of election day. So election days always happen in November, as we know, and then what would happen is the president would be inaugurated in March. And the problem with that was you would have 4 months that would pass. Right. So November and then December, January, February would pass. And then here comes March and then you would be inaugurated. The problem is this. Well, or here's why that was set in the first place. Um, it gave time for the newly elected president to get everything in order. And the reason why that was set was because, there's communication problems, there's transportation problems, you've got to ride your, there's horse, but you've got to ride your horse from wherever to wherever. Um, you know, in 1933, that's not a problem anymore. In 1933, communication problems are resolved. You can ride the train. You can send a telegram. You can call on the phone. It's not that big of a deal. Uh, and then the other thing is this: the lengthy lame duck period, the 4 months is way too long. 4 months is way too long between presidencies, right? Um, I'll give you an example of why it's way too long. Before Abraham Lincoln became president of the United States, so he's elected in November, becomes president in March, right? In those 4 months, uh, you had the complete dismantling of the United States. And I'm not exaggerating. 11 states seceded from the Union. 11 states seceded from the Union. And James Buchanan, the most useless waste of space who called himself a president, and I'm not exaggerating, he is the worst of them. James Buchanan sat there and said, well, that's just too bad. He did absolutely nothing. I mean, if I ever got a chance to beat up a president, bring me James Buchanan, because that dude, I could totally take him, first of all. Secondly, that dude, a waste of space, a total waste of space. And in the 4 months that Lincoln was waiting to take over as president of the United States, James Buchanan did nothing. So that's what we're talking about here. The 20th Amendment changes it to where now you have much less time and the new president can take over in a little over a month. So essentially about a month and a half to almost maybe 2 months, but not even that long. The other thing is that it also sets the congressional takeover date for January 3rd. So Congress gets to work very quickly, which is also incredibly important. The 20th Amendment also has an additional rule, and that is if the president-elect dies before inauguration, the vice president-elect will become president. And it's an important rule to set in just in case, because it's essentially eliminating any debate or conversation. The idea is that if the people have elected the president and vice president without any doubt or any conversation, this is what's going to happen. Okay, so the Third Amendment is the 22nd Amendment, which was ratified in 1951. The 20th Amendment was in light of Franklin Roosevelt, and I've already talked about why the 20th Amendment was necessary. The 22nd Amendment, 1951, is also going to be about Franklin Roosevelt. So I'm going to talk about why. So this limits a president to 2 terms or a maximum of 10 years if they finished out the term of a president who had died or resigned from office. So let's talk about what's going on here. So Franklin Roosevelt was okay. So Franklin Roosevelt, well, okay, let me go back. Serving only 2 terms prior to Franklin Roosevelt, serving only 2 terms was a self-regulating limitation. It was the norm, but it was not a rule. And let me just emphasize that. It was the norm. It was something that presidents had just done, but it was not written anywhere in the Constitution. Nobody actually said you can only um, have 2 terms as president and then you've got to go away. George Washington set that norm. He's the guy who ran for president, then ran for reelection, and then left. And then everyone afterwards just followed that lead. When John Adams lost his reelection campaign, he left Washington, went back to Massachusetts, and stayed there. He did not come back to try and win the office again. He just accepted defeat and called it good. He's not trying to come back and regain the office. They just accepted defeat. That was that. Now, there are a few who will challenge that, like Grover Cleveland ran for president and won it in 1884. He ran for reelection and lost in 1888, but then he ran again in 1892 and he won. So he ran a total of 3 times, but then he won twice. It was just, he skipped the middle term. Um, Theodore Roosevelt became president in 1901. And the thing is, though, he took over as president as a result of an assassination. He was actually the vice president of the United States, but William McKinley had been shot and killed. He was assassinated only a few months into his term, literally just a few months. And then that was in 1901. And then Theodore Roosevelt ran as president on his own terms in 1904. And then because he made a promise, okay, I'm not going to run again for president, he didn't run in 1908. But he decided he was going to make a run for it in 1912 and he lost. So there are some little anomalies here and there, right? There are some people who will challenge things or change things up, but they don't actually break the rules, right? They just change things up, but they don't break the rules. Then there's Franklin Roosevelt. And Franklin Roosevelt challenges the rules and then throws everything on its head. Franklin Roosevelt ran for president and won in 1932, and then again in 1936, and then again in 1940, and then again in 1944. That's the thing. He won 4 times in a row. And what ended up happening is just a few months into his 4th term, he died. That's the only thing that stopped him from actually serving as president of the United States for 16 years. Otherwise, if he were a healthy man, he would have. But he was physically very ill. And so the thing is that the reason why this man is elected to office 4 terms in a row is because he is wildly popular. And he's also leading the country through the huge traumas of the Great Depression and World War II. And so the Republican Party, in answering Franklin Delano Roosevelt and the fact that he is that popular, the Republican Party was like, we are never going to go through that again. And that's why there's the 22nd Amendment. You have 2 terms and maximum 10 years. After that, get out. You cannot live there forever. The White House is not your retirement home. That's that on that. Okay. Now, the last amendment is the 25th Amendment, which was ratified in 1967. So the 25th Amendment is about this. If the president dies or resigns, the vice president shall become president. Okay, guys, I realize this is common sense, or it seems like common sense, but I want you to think about something. This was not in the Constitution. There was nothing like this before. There has been it had been stated in the Constitution, but it needed to be reinforced because of previous situations. Let me explain why. That's not what I wanted. Let me explain why. Okay. So, William Henry Harrison was the first president to die in office. He was not assassinated, he died. He died because for his inauguration, during the freezing cold weather, he decided he was going to give an extremely long inaugural address. He got sick. He ended up getting pneumonia, and that's how he died. So he never actually even served as president. Okay, let's move on. His vice president, John Tyler, ended up becoming president. Okay. And there were people who actually argued that Tyler should only be temporarily the president of the United States. And Tyler said, absolutely not. I was Harrison's vice president. I was on the ballot, the same as Harrison. So people voted for me, just like they voted for him. And also, people did not want to pay for another election. And so they didn't. And Tyler became the president of the United States. And over the years, other presidents would die in office. They would be assassinated. Grover Cleveland, I think, Grover Cleveland was assassinated. McKinley was assassinated. Um, but that continuing argument of being temporary, that a vice president who becomes president is somehow illegitimate, that sort of hangs over them. Um, that argument continues to hang over them as if they're not really the president of the United States. So the Constitution had no provision um, that established that the vice president would become officially the president of the United States. Not only that, but the Constitution did not have a provision allowing for the replacement of the vice president. There was nothing for that. So there are several presidents who served without a vice president, especially those presidents who became president upon the death of a president. So under the 25th Amendment, the president can nominate someone, and Congress could approve with a majority vote. So a perfect example of this was when Richard Nixon was president of the United States. His first vice president was a guy named Spiro Agnew. Spiro Agnew had to resign because he was brought up on charges. There's a whole thing. And he was nearly impeached and removed from office. So before he could be impeached and removed, he resigned. Nixon chose a guy from Michigan named Gerald Ford. Gerald Ford is a super nice guy. Everybody liked him. The House of Representatives, a majority of them said, yes, we like this guy. He became vice president of the United States. Okay. And then, of course, Richard Nixon would eventually have to resign as president of the United States. And before you know it, Gerald Ford, who accidentally became the vice president, now accidentally became president of the United States. Gerald Ford is the only guy in American history who had never been elected to the vice presidency and then the presidency. He ran for the presidency. He ran to be elected, but he never won. So if the president is temporarily disabled, or he is unable to carry out his functions as president of the United States, so say, for example, if the president has to go through major surgery of some kind and he's under anesthetic, he has to inform the Speaker of the House in writing. He's got to write a letter, and the VP will serve as the president until the president writes another letter saying that he can resume his duties. I remember this happened when Bill Clinton was president. He fell and hurt his knee, and they had to repair cartilage in his knee. And so he was going under general anesthetic, and Al Gore had to be president for a few hours. So there is a letter. There is a letter in the archives that basically says, I am giving up my duties as president of the United States for this time. And then there's a second letter, and the second letter says, all right, I'm awake now. So now everything's normal. With, for John F. Kennedy, of course, John F. Kennedy was assassinated in 1963. And, that was an issue. But one of the questions that has been presented was, what if Kennedy had survived but ended up in a coma? What then? Because if he's in a coma, but there's no letter where Kennedy has signed the letter that says, I can no longer perform my duties as president of the United States, how would he be able to, if he was in a permanently disabled state, there was no clear way for the vice president to succeed, right? And to take over. That's why it was important for the 25th Amendment to exist, right? Okay. So now that we know what the president does, the responsibilities of the president, and how the president is limited in certain tasks and responsibilities, and that sort of thing, I want to end this particular lecture by talking about the judicial branch. And this is the thing. In Article 3 of the judicial branch, or in Article 3 of the Constitution, we learn about the judicial branch, but the irony is this. It is the least defined of the major branches of the federal government, right? The Constitution establishes a Supreme Court, but when we talk about its definitions and its parameters, Congress defines what the remainder of the federal court system does, where its powers lie. The Supreme Court itself is what's established by the Constitution. The remaining parts of the federal court system is defined by the Congress, right? Here's the thing. A judge in the federal court system can be appointed for life and can be removed from office because they are an official through the impeachment process. And weirdly enough, it is Article 3 that will define treason. And treason is the one and only crime that has been defined in the Constitution. Treason, if you're looking at the actual definition of treason, treason is aiding or abetting the enemy. And treason is also defined as waging war against the United States. Treason is aiding or abetting the enemy. It is also defined as waging war against the United States. Now, there has to be two witnesses to the event, and Congress has to be the one to decide punishment for treason. Now, if you are accused of committing treason, your family is not punished. It's just the person or the persons accused of treason. But anyone beyond that is not punished. But it's really interesting that treason itself is the only crime that's specifically defined in the Constitution. And the reason why is because the founders are explicit on what it means to be loyal to the country and why that matters, right? Now, in terms of explaining or understanding why the judicial branch matters, right? What the judicial branch, what Article 3 will establish is things like precedent, right? Precedent will refer to a court ruling that has bearing on future legal decisions. Uh, so I'm going to say that again. It is a court ruling that has bearing on future legal decisions. It's important to know what these rulings are so that you understand what the system is like. You understand how to work within the system. Any court, whether you're talking about the Supreme Court or any of the lower courts, every single court reviews previous cases related to the case at hand. They are going to review previous cases. They're going to review how those rulings were established. It's incredibly important because otherwise, if you're only looking at the case in front of you, it's you're not going to be able to understand how you got there in the first place, right? Another thing that you've got to know about the judicial branch, and when we talk about the judicial branch, remember, we're not just talking about the Supreme Court, we're talking about the entire system of courts, every level of courts, right? An adversarial system is when two parties work out their differences. The court is designed to work as a neutral arena where two parties, whether it's two individuals or two companies, whatever, they work out their differences. But the court hosts it as a neutral arena. Now, another thing that you have to understand here about the judicial branch is that a court cannot instigate a case. A case has to be brought to the court, right? So somebody else has to investigate it. Somebody else has to find evidence for the case. Somebody else has to bring up charges. A court is never going to instigate anything. Like a judge cannot arbitrarily decide that they have interest in something and then bring it to a court. Like if I were a judge somewhere, I cannot just start investigating something and then decide, okay, I need these prosecutors to go and work with these detectives and have those detectives arrest these people. That's not how it works. It has to be brought to the court. On that note, it has to be a real case. I cannot work, or a judge cannot work with hypothetical cases. These have to be actual cases, real issues. Courts cannot create laws. Courts have to apply actual laws. So the only body in the government that can create laws is Congress. Congress creates laws. Courts can review laws to make sure that they are constitutional. So courts can review laws, but courts cannot create laws. And that leads me to the Supreme Court. The Supreme Court's responsibility is judicial review. And judicial review is deciding whether or not a law or an action has violated the Constitution. That is the Supreme Court's primary responsibility. Has the law that Congress passed or has somebody's lawsuit or has somebody's action or inaction, is that a violation of the Constitution? Is that a violation of the 14th Amendment? Is that upholding the Second Amendment? Is that a violation of the First Amendment? That is the Supreme Court's responsibility, right? Deciding whether or not a law or action violates the Constitution. It is of utmost highest importance that the Supreme Court knows the ins and outs of the Constitution, right? That's and the Supreme Court is incredibly important, not just for the highest cases, but for everyday Americans, because it affects everyday Americans, as I've mentioned before. Okay, the jurisdiction of the federal court. Any case where there may be a broader constitutional law, meaning any cases dealing with the Constitution. So when we talk about the federal court, and again, this anything with the Supreme Court, anything like the federal court system has districts across the county, right? Across the country, excuse me. We have districts across the country, including Oklahoma. So anything dealing with the Constitution, um, that is going to get to a federal district court. And this is dealing with federal law. So anything dealing with federal law, whether it's issues dealing with federal law, treaties, if we're dealing about questions of maritime law, so disputes about bodies of water. So if you shared a body of water, whether we're talking about access to a river, so and this was actually a long time issue with the state of Texas between Oklahoma and Texas. There had been a long time border dispute over the Red River. And Greer County, there had been a long time border dispute that is a federal issue because the federal courts had to decide what was going on there. Especially and concerning the Red River, when there are questions about citizenship, whether it's dealing with American citizenship or if someone who is living here and they have a question about citizenship, they deal with the federal courts. As I mentioned earlier, disputes between the states, other countries, and other countries' ambassadors. Um, this is a rather structured system, right? It is a three-tiered system where you have the district court and you have specialty courts that's at the bottom, right? So um, when we talk about um, these these specialty courts, the specialty courts are at the bottom, and then there's the district courts, and the Court of Appeals are also included there at the very, very, very top. And it's not included in this three-tiered system because it's too high above them. That's the Supreme Court. So it's the Court of Appeals at the top, then it is the district court, and the specialty courts are at the bottom. So the Court of Appeals and the specialty courts, but Supreme Court is at the very bottom. Now, in your book, what you will see is how we get to a Supreme Court case. If you've ever thought about this, and you want to be able to argue a case before the Supreme Court, first you have to achieve this. And that is the rule of four. The rule of four is very straightforward, and that is four of the justices must agree to hear a case. Four of the justices must agree to hear the case. Now, here's the thing. The Supreme Court hears anywhere from 50 to 60 cases a year, most of them dealing with the Constitution. The United States is usually considered the defendant. And when we talk about what these cases are like, the cases are usually going to have broader national implications. So if you're suing your Aunt Louise because, she ran over your mailbox, that case is not going to make it to the Supreme Court. Let's just get that out of the way. But if we're talking about a case that is dealing with issues of discrimination, issues about citizenship, issues about identification, issues about, you know, women's rights and body identification, rights to healthcare, rights to all of these larger issues with huge implications for all sorts of people, then we're cooking with something, right? um when we talk about all of these other issues, though, I want you to take a look at what the book has to say here, um, because there are huge implications as to what happens when uh, when a case actually does make it to the Supreme Court, and what happens as a result, right? Supreme Court opinions, to win a case before the Supreme Court is a matter of just winning a majority, right? Winning a majority is basically 5-4. However, um, getting an opinion from the Supreme Court is important whether you win or not, whether your case wins or not. The majority opinion is written by regardless, is written by whoever the senior justice is in the majority. So if it's written by if the chief justice is in the majority opinion, then the chief justice will write it. In the dissenting opinion, it is written by whoever is the senior justice in the minority. um when we talk about it, uh, there are plenty of dissenting opinions that are incredibly powerful and moving and just as important as the majority opinion. Um, and if you are looking for, you know, Supreme Court opinions that are history making, that shape our understanding, not just of American law, but that shape our understanding of how the law and humanity intersect and impact each other, please let me know, and I can show you several examples of why they all matter. But in the meantime, read this chapter and read this section thoroughly and carefully, because it does matter.